Welcome to my channel, All for Health with Jane. The Senzo Meyiwa trial continues. We are still on a trial within a trial. Family, when Magistrate Vivian Kronye gave a version of how it went when she took down Bongani Ntanzi's confession statement, Magistrate Kronye indicated she had an audio recording she took during that process, and she even said she did that without the knowledge of Bongani Ntanzi, his lawyer, and the interpreter. She said she normally takes an audio recording for her own personal purpose. Today, the 18th of October 2023, when we expect to hear the cross-examination done by the defense to Magistrate Kronye, the focus is on the recording that the court initially said they were not going to consider it. After Advocate Baloyi had listened to it and realized that the audio recording had more information than what was on the confession form, the state suggests that the audio recording be brought in court and be admitted as evidence. This was quite a U-turn by the state.
Compared it to Exhibit JJ, the performer. They are naturally, Exhibit JJ would never contain a verbatim recording of what was said. And after having compared the recording to Exhibit JJ, the performer, there are certain aspects that are not contained in Exhibit JJ, which appear in the recording, which in our submission are important to determine whether the statement in question was made voluntarily. And my Lord, also after having looked at the relevant legislation as far as this point is concerned, we are of the view, my Lord, that the provisions of the regulation of interception of communication and provision of communication related information Act number 70 of 2002 is applicable, in particular section 4 thereof. This section, my Lord, section 4 provides that that any person other than a law enforcement officer may intercept any communication if he or she is a party to the communication, unless such communication is intercepted by such person for purposes of committing an offense. We therefore submit, my Lord, that the magistrate was entitled to record the deposition of this confession. She is a party to the communication, even if she did not inform the parties. In terms of the section 4, we submit, my Lord, that all that is required is that the person making the recording need only be a party there too.
To be honest, this will be unfair to the defense if the court allows the audio recording to be used as evidence when yesterday they were told the audio recording was not going to form part of the evidence. After hearing that the audio recording was not going to form part of the evidence, the defense obviously did not listen to the audio recording and did not prepare their cross-examination questions accordingly. The defense therefore made the following request to the court.
By it, I would actually submit and request the Honorable Court to suspend the submission made at the moment for the defense to continue the cross-examination and make proper preparation in response towards the submission made by the state, my Lord. I am ready, my Lord, to proceed with the cross-examination and request that whatever material that the state will use during further submissions should be notified in time or timelessly so that we cannot be carried by ambush.
I see.
Court pleases.
Mr. Ngumalo?
My Lord, my back is against the wall because I'm saying my back is against the wall because it is accused number 2's.
Yeah, but you're an officer of this court. You're supposed to assist this court to reach whatever conclusion is justifiable on the.
I'm also of the same view.
Okay.
Yes, I'm also of the same view because the state yesterday indicated that it was not going to use the recording. So I had felt that it was not going to be necessary for me to go through the recording, but hence the issue is coming up again. I'll request that I be given an opportunity to go through the recording and make my submissions properly.
Fine.
Thank you.
Mr. Msholo?
As the court pleases, my Lord. My Lord, I also object to the application brought by the state at this hour. Since, my Lord, yesterday, it was clearly indicated that the state was no longer intending to lead this information. And hence, as a result of that, my Lord, I listened to the recording alone without my client. My client has never listened to this video recording. I have not been given instructions regarding that because I was under the impression that the state was not going to use that information. As a result, my Lord, I will ask again, as I've asked yesterday, that will be given an opportunity because if the state is allowed to proceed at this moment, my Lord, that will amount to an ambush on the part of accused number 5, if I may speak for my client, my Lord.
Okay.
As the court pleases, my Lord.
All right.
The court adjourned for almost 4 hours, the defense together with their clients listening to the audio recording. Coming back to the court 4 hours later, the defense ready, to question the court about the authenticity of the recording as well as the lawfulness of how it was obtained, where the people recorded were not aware of this activity. Based on that, they argued that this audio not be made and admitted as part of the evidence for this trial within a trial. Family, this trial within a trial may also take longer than we thought. According to the state, the intention was to take at least a week, but it may take more, as it is the right of the defense to be given more time to consult. Hope at the end, the court is able to achieve the purpose of this trial within a trial. Family, hope the real killer of Senzo Meyiwa is found and go to jail. To be honest, it would be unfair for innocent people to go to jail. For in case if none of these 5 accused know anything about this, it's gonna be unfair for them to go to jail. Let the real killer be found. Thank you, family. Thank you very much for watching this video to this point. Please like it before you leave. Subscribe for my channel if you haven't done so yet. I love you, family. I hope to see you on my next upload. Thank you. Bye.